Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, as we know, last week on Friday, there was all sorts of big Second Amendment news, including that the United States Supreme Court had accepted review of a huge Second Amendment case. Of course, that's the bump stock case of Cargill v. Garland. Did you know that the United States Supreme Court also accepted a second gun case? Oh yeah, it's a big one, and it has a plaintiff that you're not used to hearing around here. But this case so much doesn't have a lot to do with the Second Amendment as it does the First Amendment, but it is huge nonetheless. So today, let's get you all educated and let's talk about the other big gun case going before the Supreme Court next year. Okay, so the case we're talking about today is a case that has been accepted for review by the United States Supreme Court. That is the case of NRA v. Vullo. Yes, for those of you who geek out on the channel regularly, yes, let's welcome to the Plaintiff Club the NRA. Now, this is a lawsuit that goes all the way back to some activity in 2018, shortly after the horrific Parkland shooting. Maria Vullo, who was then the superintendent of the New York State Department of Financial Services, sent a letter out to many financial institutions across New York saying that they should really reconsider their relationship with the NRA and many other pro-gun or pro-inalienable right organizations. She also suggested that all of them should really be worried about the reputational risks that would occur if you were to do business with such horrific organizations such as the NRA. As a matter of fact, Ms. Vullo was quoted in that letter as stating, "Subject to compliance with applicable laws, the department encourages its chartered and licensed financial institutions to continue evaluating and managing their risks, including reputational risks that may arise from their dealings with the NRA or similar gun promotion organizations, if any, as well as continued assessment of compliance with their own risks of social responsibility." That's right, this is a government employee preaching to private companies how they need to preach social responsibility, which wasn't done there, because the letter also stated, "The department encourages regulated institutions to review any relationships that they have with the NRA or similar gun promotion organizations and to take prompt actions to manage potential risks and to promote public health and safety." Now, notice how she is actually singling out the NRA by name, and then of course any other, those nasty gun organizations. But she wasn't done there, because the letter also stated, "There is a fair amount of precedent in the business world where firms have implemented measures in areas such as the environment, healthcare, and civil rights in fulfilling their corporate social responsibility. The recent actions of a number of financial institutions that severed their ties with the NRA and have taken other actions after the AR-15 style rifle killed 17 people in the school in Parkland, Florida, is an example of such a precedent." Okay, so first of all, she believed that an AR-15 rifle went into a school in Parkland all by itself and killed 17 kids, even though we know there was a maniac behind that firearm. But hey, don't let the facts get in the way. But also says, hey, all these companies that are just basically cut the NRA off, well, they're doing exactly what you should be doing. Now, what the NRA is claiming here, and they're right, is that this is essentially a government-sanctioned blacklist that is based upon criteria that deals with protected speech. And here's the other thing that those who think that this is a good idea should be concerned about, is what if all of a sudden this same type of shenanigans was used in a very conservative state to squelch speech that might be considered liberal-leaning? In fact, the ability to abuse this is so great that one of the great allies that the NRA has on this particular suit, I'm not making this up, is the ACLU. That's right, the American Civil Liberties Union actually and wisely recognizes that, hey, listen, if the state of New York could do this, what could the state of Oklahoma or the state of Texas do to something on the other side? And that is exactly right. And we also have to remember that this is a state in New York now that is beginning to believe that they have the authority to preach what the social responsibilities and the moral obligations are of privately owned entities. Now, just so you understand, the trial court originally found in favor of the NRA. However, on appeal to the Second Circuit believed that the NRA couldn't even establish a claim, that Ms. Vullo had done absolutely nothing wrong, and actually dismissed the lawsuit outright. The NRA then appealed to the United States Supreme Court, appealing the Second Circuit's dismissal of this case, and the United States Supreme Court has in fact accepted it. Now, here's the important thing. Is even though this is going to be talked about like it's a gun case, this is really a case that's not going to have much of anything to do with the Second Amendment, okay? But it is going to have a lot to do with the First Amendment. Specifically, can we regulate commercial speech and to what extent? But this is going to give the Supreme Court an amazing opportunity to go into and to shut down what we're seeing a lot of state governments, those that have a tendency to be a little bit bluer in nature, where they believe that not only do they get to dictate certain aspects of our lives, but they also get to dictate how we think, how we believe, what we hear, what we see, and how we respond to social events. And specifically, even though there was multiple issues that was petitioned to the Supreme Court to be reviewed, the Supreme Court has accepted review on very limited issues. So the only issues that are to be decided in the case of NRA v. Vullo are whether the First Amendment allows a government regulator to threaten regulated entities with adverse regulatory actions if they do business with a controversial speaker as a consequence of A, the government's own hostility to the speaker's viewpoint, or B, a perceived general backlash against the speaker's advocacy. Okay, so the case once again is NRA v. Vullo. It has been accepted by the United States Supreme Court for review. We will link it all up down below so you can geek out on it. Now, there will be quite a bit of time between now and when we get close to oral argument. We will have a time to review the pleadings and see where the sides are going. It's going to be very interesting to see this unique alliance between the NRA and the ACLU. If you got any other questions about this, or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.